The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon again, Nashville. Welcome to another Ask the Experts. We have got an incredible show today, and I want to just say that this is going to be our second show with this expert. And I got to tell you, this is my 15th year doing Ask the Experts. And I have seen just about everything. But our last show, we had 4 law firms to contact us after the show. And the only reason I'm bringing this out to you is they were so impressed with the show. They wanted their own show, though we are committed to our expert attorney, Alex Busher. But what was amazing, why I'm bringing it up, is each one of them said how the information our expert was giving out was so good. And what's so amazing about that is we get calls like that all the time. You never know who's listening or watching the show. But a lot of times they'll go, well, they've got a bad reputation, or they're giving out whatever they can to hype themselves up. But to get 4 law firms in Nashville, actually, one was in the Memphis area who somehow found the show, but to get 4 firms saying that the information the expert is giving is right on, that's amazing. Let me introduce you to our great expert, Alex Bushner. Good afternoon, Alex.
Good afternoon. How are you today?
I'm doing good, buddy. Like I said, I haven't probably had that in 15 years, that everyone responded were attorneys. I guess that some of them knew you and said what great information that you were sharing. And that's what this show is about. We're out there to educate you, because there's some people who just kind of wait around. And I got to tell you, what we want people to understand is they need to get in, at least get a will or a trust drawn up. And that's what you do with your firm, right?
It is. And first of all, thank you very much for having me back. And I appreciate that there was great feedback from the show last time. I do try to provide, as much information as I can without getting into the area of legal advice. But what I will say is, in a state like Tennessee, a trust is really a better tool than a will. In some states, you're able to avoid probate by, using certain types of deeds, like beneficiary deeds, or certain types of instruments like transfer on death of motor vehicles. But Tennessee doesn't, unfortunately, doesn't have statutes that allow for those type of documents to be respected. So in that case, if you have any real property and it's not in a trust, you're going to end up going to probate. If you have vehicles and you haven't titled them in the name of a trust, they're likely going to end up being probated. That there are some workarounds to some other assets, like 401ks, IRAs, life insurance, because you can add beneficiary designations. But if you have real estate in Tennessee, you really should have a trust. And the reason is if you have a will, it's pretty much an invitation to sue yourself once you die. And unfortunately, your kids or whoever you deem is your executor, if you have a will have to be the one enforcing that lawsuit against your own assets. So putting a trust in place is really important in this state. And then there are additional benefits beyond just avoiding probate, where you can set these trusts up to protect your beneficiaries' assets for their lifetime and even for multiple generations, depending on who you choose as your trustee and the state in which you set these up. So yeah, really appreciate being having the opportunity to come back on here and help get the info out that's needed, because a lot of people don't understand what a massive pain probate is and
Yes.
what happens when you
How
pass without
expensive.
any documents. Yeah.
It gets very expensive. Hey, Alex, we want to find out more about your firm, but before we do, so you also represent people in the music industry, and I wanted, and here we're talking about trust. Were you surprised that Prince did not even have a will?
I was very surprised. That being said, there's some complications in the music industry that don't apply to the everyday person. A lot of their income is coming from royalty streams, which a lot of times they've assigned to other parties through contracts. And then a lot of times they've set things up through trusts. So if he didn't have a will, maybe a lot of what was he passed on was in trust. I don't know his estate well enough. But if you set up trusts in states like Wyoming, like South Dakota, which anybody in any state can set up, then those trusts are completely private, and you would never know what assets were in those trusts, who owned it, where they transferred to. So, that's the other issue with going through probate is, for my music business clients, I always advise we put trusts in place, because everything in probate is public. So that means that the public can go through every asset you owned at your time of your death, and then also see if there's any juicy details about family disputes and will challenges and challenges to the estate. So I just find that really everybody with any sort of assets at all, especially if you have kids, needs a trust. And then the music business side, it's even a little bit more complicated, keeping their assets out of public light. Keeping family disputes out of the public light, but also just the complication of the assets that they do have, and whether those have been assigned or are going to continue to roll into the estate, and then dealing with those, or if they haven't been assigned, dealing with how those rights get distributed among the heirs. It gets really complicated. So I also do a lot of work with the hemp industry, and I've worked with the hemp industry since it was legalized in 2018. And for a while, nobody in the hemp industry knew if they could take bankruptcy, just because cannabis industry, anybody that was even ancillary to the cannabis industry couldn't take bankruptcy. So they had to set up different strategies for asset protection, or else they could have lost absolutely everything and still had debts to pay, because they wouldn't be able to have bankruptcy protections afforded to them. So, I handle everything from very basic estates, trusts, even for single people, all the way up to extremely complicated estates where we're looking at estate tax issues and how to best handle those, as well as very interesting asset classes and how those get passed on to future generations.
Alex, I would think your music side of your practice is a little younger audience versus estate planning. Is that true?
Yeah, it is. But
how do you explain to a 25-year-old how important this is to do now?
So generally, I'm not, generally, unless that 25-year-old has kids in the house, which most 25-year-olds right now don't, especially if they're musicians. Sorry. Yes. I'm a musician. I didn't have a house and a wife until, 30, so, or plus 30 plus. So really, with those musicians, I'm mainly doing music business services. So we're talking about regulatory compliance, protecting their copyrights, good contracts, probably keeping them away from the major labels right now, because they're not developing anybody. They're just essentially taking money from people that have already developed themselves, unfortunately. So that's more of what I'm doing for the younger musicians. Once the musicians have some assets rolling in, once they have, kids, a house, then it's not a hard sell, because I just let them know, look, you don't want this to be in public. you also don't want your kids to have to go through a potentially year-long process, which is really expensive and requires them going to court to end up getting your assets. Plus, you don't want to pass on this massive bundle of assets to them so that they can immediately spend as soon as you pass and it hits their account. Let's set up some protection where, if for some reason they have creditor issues and you have set up this trust for them, they can still access the trust, but the creditors can't take all the inheritance. Let's say that they have end up getting in a car accident and having somebody sue them. That lawsuit can only affect their personal assets. It can't affect the trust. It becomes more of a set up your kids for success in the future. Make sure that you're not, furthering the heartache of your passing by requiring them to go to, into a year-long potentially trust or probate process, which can easily be avoided by a trust. And then you look at just the cost of a trust versus the cost of the probate process, and it's insane the amount of savings you get by setting the trust up now versus having to go through probate, hire an attorney, and potentially have challenges and have a bit of a complicated probate process, and that can spiral into many months of proceedings and a lot of expense. So yeah,
how many times
it's not a hard sell.
Yeah. How many times do you hear an attorney say, I'm going to try to save you some money? And what you do with probate, I know there's a lot of time involved, but gosh, if you can set them up to stay out of the probate court, like you've talked about, you're really saving your client a lot of money.
Yeah. And time and energy and heartache. Because instead of having to worry about going to court, your heirs and your kids can worry about your funeral plans, your arrangements, and honoring you. And now you've set them up with this amazing, asset protection for the rest of their lives that they can add to if they want. Let's say they make a ton of money and they don't need it all in their personal bank accounts. They can add to that trust, still use that money, but now it's protected. And then they can pass that trust on to their kids, and their kids can pass that trust on to their kids. And if you set this up in the right way, in the right state, with the right trustee, these can last for up to 1,000 years because of these new dynasty trust regulations and statutes that have come out over the last 20 years. And really, it's only been the billionaires that have been taking advantage of these dynasty trusts because they were setting them up in an irrevocable way to avoid estate taxes and essentially make sure their families were set for 1,000 years. But you don't have to be a billionaire to take advantage of this. And if you don't have over 28 million, it becomes a lot easier because you don't have to worry about estate taxes, and you can set these up as revocable trusts instead of irrevocable trusts.
Alex, what's so amazing is because we do estate planning shows all over the country, so we're kind of a sounding board here, and it's amazing. People go, well, estate planning, I don't own an estate, I'm not a multi-millionaire, and they think that they have to have millions, and that's just not the case.
Nope. Under the law, if you die and you have $1 in your pocket, you have an estate. Estate, just it's what you own. So, if you have personal property, if you have personal property of any kind, you don't even have to have $1. If you have personal property of any kind, you have an estate. So it's planning to make sure that your stuff, your equity, your interests transfer to the next generation, to your kids, as effortlessly and effectively with as few taxes as possible. And avoiding the heartache and headache of dealing with the probate process and having to hire an attorney and essentially pay money out of their future inheritance to litigate a claim that could have been avoided in the first place.
You mentioned that in Tennessee that it's better to do a trust than a will. Why should people choose a trust over a will in Tennessee?
So in Tennessee, in all states, if you do a will, you have to go to probate. Some states hate probate so much that they've made it very easy to avoid probate by doing things like beneficiary deeds. So you would file a beneficiary deed in the property record that says, upon my death, the property automatically transfers to this person. Tennessee does not allow those. So Tennessee has not made it very efficient to avoid probate, except for trusts. And that's just because trust law has been around since, honestly, Henry VIII. He's who created trust law. So these laws predate our country. But Tennessee has not made it efficient outside of having a trust to avoid probate. So if you have a will, you're going to probate and there's no way to avoid it. In a state like Colorado, if you have a will, you might be able to avoid probate. And then with a trust, we always do have a pour over will. And that pour over will is a fail-safe. So if you buy a house and forget to put it in the name of the trust, the pour over will will pour that house into the trust. Still has to go through probate, which is why you want to make sure that all of the assets that you own end up in the trust, either as a beneficiary designation or in the name or through PODs or TODs. But at the end of the day, yeah, you just want to make sure that you have a trust in Tennessee and not a will. I mean, a will is better than nothing because at least you're directing the court where your assets are going. But a trust makes it so you direct where your assets are going without any court or state involvement whatsoever.
Hey, do you think the Terry Shively family wished they had done a trust or a will?
Yeah, I mean, just well, I mean, especially a trust, but the privacy protections that a trust affords are really important. So that's what I'll say.
So what type of trust do you create?
I create all sorts of trusts. I mean, I create the standard revocable trusts where things distribute at certain ages, 25, 30, 35. I create revocable trusts with a trust that lasts for the lifetime of your descendants. I create revocable dynasty trusts, which last for up to 1,000 years. I also create irrevocable trusts for like life insurance policies, because if they end up in your estate and not in an irrevocable trust prior to your death, they could push you over the estate tax limit because the life insurance proceeds are actually counted towards the estate tax limit unless you have an ILIT set up, which is an irrevocable trust. And then I set up asset protection trusts for people like doctors, lawyers, general contractors, CPAs, anybody with a lot of lawsuit liability that's worried that they could lose personal assets if they're sued. I set those trusts up as well. Crits, CRATs, which are charitable remainder trusts, really a full suite of trust services. And if your listeners want to reach out, we'll do a comprehensive review of their assets and then really recommend the best way forward.
What's the difference between, say, a revocable and an irrevocable trust? So
a revocable trust is a trust that people under the estate tax gift tax limit would set up. So revocable trusts are revocable by both parties if it's a joint trust, or the settlor of the trust if it's a single party trust or a single person trust. They're revocable until their death. So that means that if they 2 years after they sign it, hate it, they can just rip it up and it's like it never existed. If you've transferred property into it, then you have to make sure you transfer it back into your personal name. But at the end of the day, if you don't want the trust, you can rip it up. Those avoid probate. Those also can set up, those trusts become irrevocable upon the death of the settlors, which is the people who establish the trust. The trustee administers the trust. The beneficiaries benefit from the trust. So in a revocable trust, the settlor, the trustee, and the beneficiary are all the same person. That's the person who starts the trust. And then upon their death, the trustee becomes the successor trustee, and the beneficiaries are generally the kids. So for an irrevocable trust, it's quite different. You have to have a settlor, a trustee, and a beneficiary. But generally, these are set up for tax advantage reasons, and you can't be the settlor and the trustee and the beneficiary, or even really anything but the settlor if you want the tax advantages. So you would have an independent trustee, generally like a bank trust department, and then a beneficiary, which would be generally your kids or a charity or some other person that you're caring for. And once that you put an asset in that trust, it can never be taken out. So if you put a house in that trust and it's irrevocable and you sell that house, the proceeds have to stay in that trust. You can never take them out. And then that trust, once the triggering event occurs or you pass away, then it rolls to the next beneficiary. So it's held in trust for the beneficiary. And generally, like with an irrevocable trust, there's going to be a living beneficiary. So generally your kids are able to access that trust while you're living, but you're not. And really, it's once you're over the estate tax limit, it's trying to put assets that are going to continue to appreciate in a vehicle that will last past your death. So when you pass away, it's not counted as part of your estate, and therefore there's not extra estate taxes that are levied on that trust asset. So
we have a couple
more of a tax planning. Yeah.
We have a couple minutes left. We got a text from Rob in downtown Nashville. He said, "Can you explain again what a dynasty trust is?"
Yeah, so a dynasty trust, these were started about, I think the first ones were around 30 years ago when states decided to get rid of the rule against perpetuities. And the rule against perpetuities was 21 years plus a life in being. So generally, trust could only last like 100 to 120 years. Dynasty trusts came about because very wealthy people wanted to set their families up for generations into the future, and wanted to have a say about what they were going to do with their property for essentially ever. So states like Wyoming that are very friendly to businesses, not a lot of population, but they make a lot of money because they're very friendly to businesses and trusts. They started creating these, or removing the rule against perpetuities and allowing trusts for up to 1,000 years to be created. So there's two types of dynasty trusts, and they're only called dynasty trusts because of the length of time. And perpetual trusts in some states are unconstitutional, so you don't want to use that term. And they're not perpetual because they last 1,000 years, so it's not technically perpetual. So that's the other way they're getting around it. But at the end of the day, there's two. There's the original type, which is the irrevocable dynasty trust, and that was billionaires with a big, massive estate somewhere, with hundreds or thousands of acres that they wanted to put into a trust that their family could use and enjoy for the rest of time. Essentially, they'll put into an irrevocable dynasty trust, and then that family can use it forever, and the trust never dies, so there's no estate taxes. It never transfers to anybody because the trust is the owner. So then the whole family just benefits from the use of the trust. So that's the irrevocable side. The revocable side is, hey, I don't have 28 million as a married couple, or I don't have 14 million as a single person, but I still want to set my kids up so that my inheritance will continue to be invested and grow as they age. There's 100% asset protection, so it will never be taken by creditors, ex-spouses, the IRS, lawsuits. They can take disability, they can take government benefits. And if in 5 years I hate that idea, I can revoke it until I pass away. So it's all the benefits of the dynasty trust, the long-term dynasty trust, because things are invested, they're going to continue to appreciate. You have the asset protection, but you don't have to commit to it until you pass away, because you can revoke it at any time.
Alex, we've been running for those on YouTube. We've been running your phone number, but we know most of you are listening on iHeart, Pandora, and Spotify. Please give them your phone number and how they can reach you.
Yeah. So give me a call at 970-688-1131 or 615-953-0500. My website is busherlaw.com. So that's www.buscherlaw.com. And my email is alex@busherlaw.com. So alex@buscherlaw.com. And yeah, reach out. I'd be happy to set up a free consultation and see if I can help you out.
Alex will be back again with us next month. If you missed part of the show, we can go into iHeart and Ask the Experts Nashville and listen, or on Spotify or Pandora. Our show's on. Hey, Alex, thanks so much, buddy. We'll see you again next month.
Yeah, thank you for having me. I enjoyed it as always.
Thanks, bud. That's attorney Alex Buscher. That's it for us today. Thanks to our great producer, Juan. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.